And this was, I guess, a little bit more of a good news story, because even though there was no trust instrument that was able to be found, what was able to be produced was a deed of variation, which basically annexed what the advisors said was a true copy of what would have been the trust instrument. And this is the kind of case that we see quite regularly. It generally relies on the fact that ideally the accountant is able to say, look, here's a bank account established in 1997. In 1997, I was using this deed provider to provide every single one of my deeds for my client. I know I set the deed up for this client. I know I would have used this provider. I've gone to that provider and they have given me their template document from 1997, and I am able to sign an affidavit to say that that would have been the deed that we used. I've got a separate affidavit from the deed provider saying this is the deed that they were using, and therefore we are able to effectively synthetically recreate that trust instrument. Now, that case was good enough. They said that was sufficient to get it across the line and discharge the trustee duties and obligations at that point. What that style of approach means from a tax perspective, and what the attitude of a third party, particularly the tax office and creditors, is going to look like, will depend on every factual scenario.